Recording in progress.
Good morning, honorable members, support staff. My watch says it's 10 o'clock, and our meeting is scheduled to start at 10 o'clock. Welcome to the meeting of the Impeachment Committee for the Section 89 inquiry. Just wanting to check with the committee secretary, Temgosi, if we do have a quorum of members in attendance.
Good morning, Chairperson, and good morning to the honorable members. Yes, Chairperson, we do have the quorum for the meeting. You may proceed. Thank you so much.
Thank you very much, Temgosi. Just to indicate, honorable members, that this is the ordinary meeting of the Impeachment Committee. We have two key items that we are going to be looking at, and I hope you are also enjoying your constituency period. It's the second last week of the constituency period, but ourselves as the Impeachment Committee, we continue our work, and we have always said that we focus on the things that we can control, and leave the other things in the hands of those that deal with those other matters. As you would know, honorable members, that there was the interdict hearing that was held last week at the Western Cape High Court. We have been informed that judgment will be delivered on Friday at 10 o'clock in the morning. So as soon as we have the judgment or the ruling of the court, we will share it with yourselves. Temkosi, if you could just apply the agenda for us. Thank you, Temkosi. So this, honorable members, this is our agenda for the day. You will see that there's a slight swap of items from the one that was circulated earlier, which had as item number 4 the consideration of the terms of reference. So we just brought the item on the evidence leaders before that, because the one on the evidence leaders is not long. It's a short item, and we can deal with that matter as quickly as we possibly can, and then that will then be followed by the consideration of inputs on draft terms of reference. So it's just the change of orders, so we did not change the items to be discussed today. I see the end of Honorable Swart.
Good morning, Chair, and morning, colleagues. Chair, we forgot to pray, but that's we can do that another time. But I just wondered whether we would go beyond the time today, given that the draft terms of reference are, the matrix is more than 114 pages. If so, I might need to tender an apology if we go beyond 1 o'clock. Thank you, Chair.
Thanks very much, Honorable Swart, and thanks for always reminding me to stay true to what we had resolved in terms of the need to start our meeting with a moment of silence. That's something that I have to ensure that it happens. I see you, Honorable Litchfield. If I can just ask honorable members, as we have been diplomatically reminded that we're supposed to have started the meeting with a moment of silent prayer or meditation, as we had resolved in the last meeting. If we can just observe a moment of silent prayer and meditation, then we'll proceed with the meeting. Thank you very much. Honorable Litchfield.
Thank you, Chair. I think, like Honorable Swart, if we go beyond the time, I will ask to be excused. I have a joint sitting at 2 at the Pan-African Parliament. I actually have one even this morning, which I'm missing. Thank you, Chair.
All right, thanks very much. So yourself and Honorable Swart has moved ahead. I wanted to come to item number 2, which is apologies. Ask Temgosi if we have received some apologies, but noting the apologies of Honorable Litchfield and also the apology of Honorable Swart in case we don't finish by 1 o'clock. Temgosi, if you could just go through the apologies. I see the end of Honorable Daniels. I'll come to you, Honorable Daniels. If you can just get the apologies first, unless if this is a point before apologies, Honorable Daniels.
Good morning, Chairperson. Good morning, colleagues. No, Chairperson, I will wait until you give me the opportunity. Thank you.
Thank you very much. Temgosi, apologies received?
Morning once again, Chair. No apologies, Chair, except that Ms. Mbapane is still trying to join the meeting and I'm assisting her. That's all. No other apologies, Chair. Thank you.
Thank you very much.
I'm in the meeting, Chair. Thank you.
All right. Thank you, Honorable Mbapane. Honorable Daniels.
Yes, good morning, Chairperson, and thank you. I also just want to tender an apology should the meeting exceed, which I expect is going to happen beyond 1 o'clock. Thank you, Chairperson.
Thank you very much, Honorable Daniels. If we all be considerate with the time, we'll finish at 1 o'clock. But if we give long speeches, we'll go beyond 1 o'clock. But those 3 departures, in case that we don't finish the agenda by 1 o'clock, will be noted. So let's note those apologies, honorable members, and then move to item 3, the tabling of correspondence since our last meeting. Temkosi, if I could just ask you to table the correspondence that we have received.
Thank you very much, Chairperson. Chair, the correspondence is from our last meeting, which would have taken place on the 24th. So on the 25th, the first correspondence to come in would have came from the MK Party. It was a formal nomination of an evidence leader. However, on the 30th, we received another correspondence from the MK Party wherein they withdrew the nomination of the evidence leader and replaced it with another senior counsel as per what is on the screen. And then, Chairperson, on the 1st of July, we received a letter in the form of a notice of motion from the MK Party calling on the committee to subpoena the speaker and obtain the...
Just hold the Temkosi. Honorable Litchfield, is that the new hand or is the Ligas one?
I think it is a legacy hand, Chair, because when you asked me to do correspondence, it was up already, but we'll wait for the confirmation.
All right, there's no confirmation, and once we deal with this, I'll just go back, honorable members, slide back to ask that we adopt the agenda before we get to the meat of the agenda. Thanks. Continue, Temkos.
All right. Thank you, Chair. I will lower the hand of Dr. Litchfield Chabalala, then Chairperson. Yes, Chair, to proceed, then I was indicating that the motion was calling on the committee to subpoena the speaker and obtain the full unredacted legal opinions and documents relating to the President's review application to ensure transparency and enable the committee to properly carry out its constitutional mandate. The Chairperson responded to the MK Party's letter on the same day and advised that the committee's mandate was limited to investigating the Section 89 charges against the President against the president, and that concerns regarding the speaker's conduct should be addressed through the appropriate NA processes. And on 2nd of July, we received another communication from the MK party where it contends that the motion was wrongly characterized and arguing that it seeks access to a legal opinion relevant to the committee's mandate rather than an investigation into the speaker, and that the president's court challenge directly affects the committee's ability to perform its work. The MK part was therefore calling for the motion to be tabled, debated, and voted on by the committee. Chair responded on the same day and maintained the position that was set out in the previous letter, also reiterating that the MK party's request should be pursued through the appropriate National Assembly processes. And then, Chair, on the 10th of July, as members would also be aware, it was the closing date for the nomination of evidence leaders, as well as the inputs on the terms of reference. So the following correspondence mainly relates to that. Chair, it would have been a DA's formal nomination of evidence leader, wherein the names of Advocate Kate Hofmeyer, SC, and Advocate Cohen came up, and then Chair, it was the ATM's nomination of Advocate Goldberg, Senior Counsel, and then it was the IFP's nomination of Advocate Morane, Senior Counsel, Action SA's advocate of nomination of Advocate Hofmeyer, Senior Counsel, ANC's nomination of Advocate Zinzile Matebese, and just an omission that it will be reflected on the document that is to be presented by legal services on the matter. There is a second name of Advocate Taki, I just don't want to say Matima, yes, Chair. But it will reflect on the document that will be presented by legal services. And then, Chair, we also received a nomination from the EFF, also of Advocate Morane, Senior Counsel, and also a nomination from National Colored Congress of Advocate Jamie, Senior Counsel. And Chairperson, the next correspondence would have been on the 14th of July. It relates to the same matter that was raised by the MK party. And the response of the chairperson was same. Chairperson sent the letter that would have been sent on the 3rd of July to maintain the position of the chairperson. And then on the 17th of July, we received a letter from Action SA. It was a request for the Section 89 to consider sub-disciplinary findings and related evidence in the Phala inquiry. And of course, the chairperson responded on the 20th of July and indicated that the correspondence will be deposited as part of the evidentiary record for consideration by the committee in the course of its work, together with any other relevant evidence placed before it. Also, the chairperson indicated that he intends to engage with the chairpersons of other portfolio committees that would have previously considered matters relating to the Phala matter, with a view to obtaining any information that may assist the committee in the discharge of its mandate. Chairperson, that is the correspondence. It was shared. These letters were all shared with the members via email. There were too many, Chair. Sometimes when there's this number of documents, I don't normally put them on WhatsApp. So I would have shared them via email if members want to have a sight of them. Thank you very much, Chair. That is the correspondence before the committee.
Thanks very much, Temkosi. Before there are questions on the correspondence, I will just ask for the retrospective acceptance of the agenda. If someone could just move retrospectively for us to accept the agenda as it is. Honorable Swart, are you moving?
Yes, Chair, I move. Thank you.
Thanks very much. Honorable Khakau, is that you seconding the agenda?
I'm seconding, Chair.
Thank you very much. Thank you very much, Honorable Swart and Honorable Khakau, for moving for the adoption and seconding. Honorable members, those are the correspondence that have been received by the committee and myself as the chairperson. I will now ask if there's anyone that has got a question in terms of the responses that will have been given to those that have written to the committee. Honorable Dagmo.
Thanks very much, Chairperson. Greetings to all on the platform. Now, just to say that in terms of the correspondence where you have responded to the letter of MKP concerning the Speaker, I think that, in my view, is the correct response. And I think all of us are also aware of the fact that there has been other correspondence directed to the Speaker and the Deputy Speaker about proposed motions of no confidence, etc. But I think it's correct that we, as you've indicated in your letter, stick to the mandate of the committee. So thank you, Chair.
Thank you very much, Honorable Dagmo. And that's the position that we also I articulated even when we met in June, that we need to stick to the mandate of the committee. Like this is a committee with a specific function. Our mandate is not broad. We are established to deal with effectively the motion that the Honorable Zungula tabled. So we have to deal with matters relating to the charges that are contained in the original motion, and that's how narrow our scope is. And I always want to say that let's not try to broaden our mandate beyond that which is contained in the original motion, but also what's contained in the independent panel report. And like I said, and I want to repeat it, if there are any unhappiness with the conduct, the actions taken by the Speaker, let's use the National Assembly, and as if it relates to the use of finances and so forth, there's a committee in Parliament that looks at the financial management of Parliament. Let's use those channels, and let's not broaden the scope of this committee and make it a general committee. It's established to deal with the matters as contained in the original motion that was submitted by Honorable Zungula in terms of Section 89 of the Constitution. Thanks very much, honorable members. We'll now move to the next item, which is to deal with the nominations of the evidence leaders, the evidence leader, and then I'll ask Suen from legal to just present the report. We did circulate yesterday the list of those that were nominated and also indicate their availability or non-availability. Suen, could you please take us through the names of the evidence leaders that were nominated by political parties? So there's one name that was not nominated by the political parties. It was from myself, who then asked legal to cast the net a little wider and see if they could find someone outside of those that were nominated by the political parties, just in case someone says there's a name that was not listed in the correspondence. How did it make an entry there? It was my request to legal to just cast the net a bit wider. Thanks very much, honorable members. I'll now ask Suen Isaac from legal to present on that agenda item.
Good morning, Chair and members. I'm just going to share my screen that has the list of the evidence leaders. Chair, that we were requested to check the availability of the various legal practitioners nominated by the political parties to the committee that are serving in the committee. The process we used was to call the people and ask them whether they met the criteria that the committee had resolved against. The first person we got on the list is Advocate Zinhle Matebetse, SC. He indicated that he is available and interested in serving as evidence leader, but he does have a very packed diary until November. The next person was Advocate Taki Madima, SC. He indicated he's not available. The third person is Advocate Kate Hofmeyer, SC. She is available. Advocate Eshad Cohen, we contacted him. However, he does not have enough experience. He is a junior advocate at present, so he does not have the required 15 years experience that the committee requires the evidence leader to have. So we have indicated he's not available. He would be available if he would be considered for a junior. Next person is Advocate Vuyani Ungawana. Chairperson, he indicated he is available. As per the requirements that's set by the committee, which is one of them being that the evidence leader must not have a real or perceived conflict of interest in respect of the matter. In our due diligence, we became aware of a case that he had, as an acting judge, he made a ruling and did refer to the matters related that were discussed in the independent panel report. We did put that to him, Chairperson, and asked him whether he felt that this issue would give rise to even a real or perceived conflict of interest. He did respond to us in writing, and his view was that he is not conflicted in relation to serving as evidence leader. He states that he's governed by Clause 58 of the Legal Practitioners Code. These public utterances in the judgment of Mogai and others versus City of Tshwane Metropolitan Municipality were criticisms of the legislature and not the president. And he also feels that he was vindicated by the Constitutional Court. He says that in any event, his views expressed on the Phala issue are irrelevant. He points out the fact that the evidence leader is not required to find the guilt or innocence of the president. The evidence leader will be required to lead evidence. And he also refers to the case of NDPP versus Zuma, which the court said the motive of a prosecutor is not relevant to the lawfulness or unlawfulness of a prosecution. So in summary, he's of the view that although he's made public comments about the independent panel report and matters related to Phala, he is not conflicted. The next person we contacted was Advocate Morani. He's not available. Advocate Doran Goldberg as well. He indicated he's not available. Advocate Ismail Jamie is available, and Advocate Pule Sileka is available as well. With regard to those counsel who are indicated they are available, as you would be aware, we would want council to comment in August, and most council already have predetermined dates, but the ones who are available can commence work in August while they still continue with matters they have already committed themselves to. So they will be able to start work in August. Chairperson, those are the list of the nominated evidence leaders, and the availability is indicated there. Thank you.
Thanks very much, Suen. Honorable members, that's the report based on the nominations that you had submitted, and I present the report to yourself. And you can then ask questions or make recommendations in terms of how we move forward. As you know that when we met last time, we had indicated that we'll bring the full list to the committee, the ones that are available, and then we will then make a recommendation to Parliament. As you know that we are not the appointing authority. We make the recommendations or reflections, and then Parliament will then deal with the issues of supply chain. But at all times, we committed that we'll be transparent with each other, but also with the people of South Africa. I see the hand of Honorable Mahlaule.
Thank you very much, Chairperson, and greetings to you, and greetings to honorable members. Let me start by welcoming the list of evidence leaders. And I think in our respective political party work, we have done well in trying to scale it down to a reasonable number, which will make it easy for us to make a determination. I just have a concern with the issues emanating from the due diligence that was done by the parliamentary legal around the name of Advocate Vuyani Ngalwana, SC. He may have a view that is not conflicted, and that would speak to real, because we have real and perceived conflict of interest, and a person must satisfy the two. If he feels that he is not conflicted in real terms, and we come to a conclusion that we perceive him to be conflicted, I think that satisfies the view that may come to say he doesn't satisfy the issue of real or perceived conflict of interest. And my view is that for us to enter into a clean process, we need to look at the perceived conflict of interest that is around his name, and rid ourselves from entering into a, for a lack of a better word, dirty relationship with perceived conflicted people on the matter. So I would propose that if it's supported, we eliminate the name and be left with names that will not create problems for us when we move forward. And that would say we are left with Advocate Kate Hofmeyer, Advocate Ismail Jami, and Advocate Pule Seleka. Now, we are meeting these names for the first time, and when I say for the first time, I mean formally. We may not know who Ismail Jami is, Advocate, and Advocate Pule, because we did not nominate them ourselves. They were nominated by some political parties. And we don't want to disadvantage these people because we have never seen them in a commission of inquiry like Advocate Kate Hofmeyer. And we want to suggest that maybe let's allow political parties to also do due diligence on the advocates, maybe extend it with a 48-hour, which is 2 days, and it will be a Friday, to satisfy ourselves that we know, so that when we engage with political parties, we don't engage from a disadvantaged point of view. And that will assist us, Chair, because you mentioned that the judgment of the Western Cape High Court will be released on Friday. Maybe this exercise may be as futile, depending on the judgment. And if the judgment says we proceed with determination. So that's my proposal, that let's extend with 48 hours, and also allow other parties who may want to nominate others, because we didn't know some are not available and so forth, to do so and move forward. There are two proposals: extension and the elimination of Advocate Ngalwana. Thank you very much.
Thanks very much, Honorable Mashaule. Honorable Daniels.
Thank you, Honorable Chairperson. Honorable Chairperson, I'll be very quick. I just want to put on record our dissent that we're not appointing authority. We're not the appointing authority. That Parliament has that competency, like you have said earlier on, Chairperson, and you're quite correct. But it doesn't take away the reality of some political parties nominating senior counsel Those nominations will be procured eventually, which may have the prospects of bordering or being synonymous to a political appointment disguised as having been through the parliamentary procurement processes. There's no ways that it can exclude that close proximity of the party who's nominated to the one who's eventually going to be procured through the processes. I just wanted to express our dissent on that, and that we shall not partake on nominating any, or not nominating, on deliberating on this particular item other than expressing our dissent to that. Thank you, Chairperson.
Thank you very much, Honorable Daniels. Dissent noted. Honorable Advocate Breitenbach.
Thank you, Chair. Good morning to everybody. I'm persuaded by the argument put forward by the Honourable Mahlaula. We would support a short postponement in order to round up on the due diligence, and perhaps we can have discussions between the parties and reach consensus on a candidate. It would be, I think, worth the time to try and reach that consensus. So I support that proposal. Thank you, Chair.
Sorry, Chairperson, I've raised my hand. Chairperson.
Honorable Shope, I will note you. I'll note you. You'll come. You'll come, Honorable Shope. I'll add you on my list because I don't see the hand up here. I'll add you to the list. Honorable Ngobeni.
Thank you, Chairperson. Given that, and good morning to all of the colleagues. Look, we are not opposed to the 48-hour proposal that there should be further deliberations for members to be able to do their due diligence. However, the idea of a further nomination or further nominations for us is not something that we would entertain, particularly because members or political parties were not limited to the number of nominations that they would have. And if we are to do further nominations, then we are also going to ask for a further 48 hours for us to make our due diligence. We agreed as a committee that we were going to nominate by a particular date, which all political parties submitted to, and then we've come to this point. And now that we have to deliberate on this matter, we are asking for a further 48 hour, and that is fine at this particular juncture. But we would not support that there should be any further nominations. We've got 4 names to work with. There's a suggestion that one be taken away. That's perhaps what we should be discussing, and then go forward from there. But there's no point in making any further nominations. And I would leave it there for now. Thank you very much, Chairperson.
Thanks very much, Honorable Vessels.
Thank you very much, Chairperson, and good morning to yourself and to the colleagues on the platform. Chair, I also agree with the proposal that we give ourselves 48 hours to do due diligence, but I also agree with the proposal that we should be left with 3 names to choose from, and that we should eliminate the one as alluded to, and that we should deliberate further and do our due diligence on Advocate Halfmeyer, Advocate Jamie, and Advocate Seleka, and that there also should not be any further nominations. I don't think that would be proper. Thank you, Chair.
Thanks very much, Honorable Zungula.
Good morning, Chair, colleagues, and everyone that has joined in on the platform. Chair, I want to perhaps start with the question of the conflict of interest. The committee did discuss and agree what is defined as a conflict of interest, that any senior counsel or advocate that has taken part in litigation on this issue would be viewed as a person that has a conflict of interest. In the event that perhaps advocate so and so has done litigation for party A, party B, for the president, against the president, that should not be viewed as a conflict of interest. So I think, Chair, let's just stick to what previously we had agreed on what is characterized as a conflict of interest, because that discussion amongst ourselves dealt with both real and perceived conflict of interest. The second issue I want to raise is that once there is over 55% of the people that are nominated that are not available, it raises some concerns whether are we having a pool that is enough to choose from, particularly because political parties, when they nominate, because they do not have any form of relationships with the people that they nominate, they would not have known whether they are available or not available, which then needs the committee to understand that having 55% of the people not available, it's something that we need to agree on the proposal by the ANC for an extension for Friday for new names. We can do it very easy, Chair. We can agree that Friday must be the new names. Between Friday and Monday morning, the legal team from Parliament is able to ascertain availability and all of those administrative issues. And then we get even if you don't need to call a meeting, you can just send us the names of the people that would then be available on Monday. Then when we meet, let's say next Wednesday, we come for a decision, especially in light of, firstly, 55% of the people nominated are not available. The second issue is that there is a name of a person that is available, and that person, the senior counsel, is a person that, according to the definition of a conflict of interest, there's no conflict of interest. However, the discussion today is to say he must be disregarded as someone we can choose from. So in light of those realities, we are supportive of the proposal to move the extension to Friday with new nominations. By Monday morning, we get the final list, and between Monday and Wednesday, as a committee, as parties, we speak to one another. We agree on the final, on who we can nominate. We do our due diligence, and then next Wednesday we take a decision. Thank you.
Thanks very much, Honorable Swart.
Thank you, Chairperson. Firstly, to deal with the actual perceived conflict of interest, the advocate refers to Section 58 of the legal practice, where he is of the view that there is no conflict of interest. But I think given the importance of this matter and the fact that every step of the way we will be under legal scrutiny and public scrutiny, I think that whilst he might pass a legal test, I think the perceived conflict of interest referred to by our colleague earlier should possibly hold sway. And I think that possibly that in the draft directives refers to real or perceived conflict of interest. And I think that is something we need to consider very seriously. Secondly, when it comes to availability, I think the criteria should be from August, obviously understanding when it comes to senior councils, they would have matters. And I do understand the concerns that 55% of the nominated members or senior council are not available. So I would support an extension for new names, given the fact of the importance of this matter in the public domain, the fact that 55% are not available. I would support that. I also support the fact that we can then consider by next week due diligence by parties, as well as finalizing the list by next week. Thank you, Chairperson.
Thanks very much, Honorable Khadebe.
Thank you very much, Honorable Chairperson. Greetings to you and greetings to honorable colleagues. Honorable Chairperson, I also want to express the IFP's support to the argument put forward by Honorable Mahlaule. I would not want to further unpack the proposal that he made, except to say that I'm rising to support his proposals. Thank you very much.
Thank you very much, Honorable Sope.
Thank you, Chairperson. Can you hear me?
Loud and clear.
Thank you, Chairperson. Good morning to you and to honorable members. Just 2 quick points. The first relates to the proposal that has been made by Honorable Mhlaule of the ANC makes eminent sense. The pool needs to be broadened, and the only way to do that is to give ourselves a little bit more time. So, you may find that there are other advocates that are readily available that will not be perceived one way or the other to be in favor of this or the other side. So I support wholeheartedly the idea of an extension by a further 48 hours. Secondly, on the issue of real or perceived conflict of interest, we should be careful not to push it too far. We can say the same thing with respect about some of these names. Advocate Kate Hofmeyr SC has appeared for President Ramaphosa, to the best of my knowledge, on more than one occasion. So it is sensible to argue that she is perceived out there as being a Ramaphosa advocate. That is not a far-fetched proposition. So we should be careful not to push this argument too far. I'm inclined to agree 100% with Honorable Zungula that we should stick to the criteria that have already been laid down, that has been agreed upon. And perhaps the best way around that is to broaden the pool, and the only way you broaden the pool is to give ourselves an extension. I must also record, on behalf of MKP, that we sent a document relating to the guidelines way back on the 10th of July. It does not form part of the batch that was circulated among members, we touched upon the guidelines as well as the evidence leader. So the document was not circulated. I put it again in the group today. Right. I'm not suggesting any bad faith on the part of Thembinkosi, but it makes sense for the document to be circulated so that our input can be shared as well. So in a nutshell, I support the idea that we must give ourselves an extension of time. Friday it makes sense to me. Further names are going to be submitted, I have no doubt, and that will also give us an opportunity as political parties to scrutinize these names. Just one final point on the availability of senior counsel. We obviously don't want any advocate who has no work at all, because you ask yourself, if a senior counsel has no work at all, nobody has confidence in him or her. But at the same time, I would caution against the following. We cannot have a situation whereby we are driven by the evidence leader. The moment the advocate has been accepted or appointed as an evidence leader, there is a duty on him or her to forego other work, return the briefs. We can't have a situation whereby we're told by an advocate, as you know, I'm not available for a week. I've got to argue a matter in the Supreme Court of Appeal or in the Constitutional Court or in the Western Cape High Court. Once an advocate has been appointed, onus is on that advocate to make appropriate arrangements so that the file can be returned. We all know that senior advocates will always have junior advocates accompanying them. So it's easy to replace them in certain matters. I know this from my years as a judge. It happens, right? So we don't want a situation whereby we're held at ransom by an advocate who claims not to be available, who wants to come on his or her terms to the impeachment committee. Priority must be given to the impeachment committee. Once an advocate says, I'm available, being available means exactly that, not subject to certain days. So I submit. Thank you so much, Chairperson.
Thank you very much, Honorable Hlope. I just want to check with the Honorable Mahlatsi. Are you covered by the previous speakers, or you had technological challenges? Before I go to Honorable Mautwe.
No, thank you very much, Chairperson. I have just 2 points, but fully agree with previous speakers. Moreover, the first speaker, Honorable Mohlaole, that I concur with the proposal of an extension and also allowing political parties to submit other names. But I don't agree with him on the issue of advocating Galwani, but I will accept it based on what he has indicated. But on the proposal of extension, also give us an opportunity to put new names, because we don't have relations with these advocates. We went through their work and we were impressed by their work. So allow us to add names. Thank you so much, Chairperson.
Thank you very much, Honorable Mahlatsi. Honorable Mautwe.
Thank you, Chair. Greetings to yourself, greetings to the colleagues and everybody on the platform. Chair, we want to support the proposal of an extension and expansion to go look for more senior councils. Chair, we only received the list from your office yesterday, and the submissions were last week. So had you known prior, we would have realized that we have a challenge, which you have realized, and that's why you then requested the legal team to expand the search and look for more senior councils. And that's basically what we are also asking for. And I understand that you did not want to share us those names so that they don't find themselves in the media space and before we deliberate on them. So for that, we fully understand the reasons why you kept the names within the office and not share them with us. Perhaps when we submit now on Friday, we can agree that we then share the names so that you allow political parties to then engage one another, lobby each other, so that next week, we already have a meeting next week that we've called. So next week, when you come to the meeting, then it becomes an easy exercise of a name that has already been canvassed among political parties, and you don't have to spend so much time deliberating on the name. So in short, Chair, we support the extension, and we also support the fact that let's go and get more people, because we have an issue here. I mean, if more people are not available, it's a fact, it is there. It doesn't really help to be left with few people, which are now as the committee confining ourselves to when we can just expand on the names. Thank you, Chair. That is our submission. Thank you.
Thank you very much, Honorable Litchfield, Dr. Litchfield.
Litchfield Shabalala. Thank you, Chair.
Dr. Litchfield Shabalala.
Thank you, Chair. Chair, I don't want to sound aggressive, but in all fairness, I just feel that we are being muzzled here. If the legal department had issues with the MKP submission, they should have written to us prior and warned us, because then we would have gone back and said, oh, we have another candidate. But for us to come here and we are told, oh, this one is falling off and this one is falling off, we are not even in agreement, actually, by the way. We are just being informed. It's not a democratic decision. I just feel that we are being colluded against, and it does not augur well. I'm not saying that that's what's happening. Please listen to my English. I say we feel and immediately there's a feeling it can grow into a reality in our heads, and then the process is compromised. They truly should have informed us, not come here and tell us your candidate is disqualified and the process is closed. We are moving forward with the names that are given on the screen. So all the honorable members that spoke have covered me, except for Honorable Khatebe. I propose an extension beyond Friday. I think I propose a 7-day one. So I think we should agree. There are two proposals on the table. Some are saying by Friday and some are saying 7 days. I think that's what we should vote on. But yeah, I agree. What we are doing right now is a process called settling. We are settling for the names that are here because some are not available. We are not sure if that's the best of the crop. We are just settling. So yeah, I think I want to propose that, Chair. And I don't know, for me, Friday is neither here nor there. Not sure this is the platform to discuss it, but it's neither here nor there. There is no lower court that can revoke the decisions of a higher court. It will go into the Guinness Book of Records. So however we look at this committee is going to continue. Thank you, Chair.
Thank you, Honorable Litchfield Chabalala. Just to say that the presentation that was made by legal indicated that the Honorable Ngalwana was available. They raised the point. Remember what we had asked was amongst the criteria, there was the issue around the conflict of interest. It would have been unfair on their part, having discovered something, not to raise it with the committee. So legal has not made the point to disqualify anyone. That's why from a legal side and also from myself, is on the list, listed as available. And we present the list to the members with the issues that we'll have picked up during the due diligence. So just in the spirit of transparency, and not tomorrow you wake up and then someone has picked up an issue and we say, but why did we not share this with the committee? So the issue on his disqualification, it's not that yet. It hasn't been decided on. I haven't put any of the recommendation or proposals to the vote. I will put all of them to the vote, and it will be the committee that ultimately have to decide on the proposals that have been submitted. Honorable Kwankwa.
Thank you very much, Chairperson. Well, I want to align myself with the submission made by Dr. Litchfield Chabalala, that perhaps on procedural grounds, Chair, to help the process, to fast-track the process when there's a meeting which has been set up or called, that if a political party proposes a specific person as an evidence leader, if there are any challenges, the legal services of Parliament must alert the relevant political party about those issues before we come to the meeting, so that by the time we come to the meeting, no one is taken by surprise. Most of the matters have been dealt with. Two, I agree. It's not a train smash. It's not earth-shattering for us to propose that we need to extend the deadline to Monday, as our colleagues have said, to say we submit the final names by Monday, and then we can meet on Wednesday to decide on who's going to be our evidence leader. So I want to support that proposal on behalf of the UDN. Thank you, Chair.
Thanks very much. Honorable, I see iPad. Who's iPad?
It's Honorable Malema.
I'll note you, Honorable Malema. If Temgos, if we could please rename the iPad of Honorable Malema, and then we can then proceed. You'll come after Honorable Ngobeni. Second bite, quick one, Honorable Ngobeni.
Thank you, Chair. No, it is going to be a very quick bite. I just want to deal with just a matter of principle to say the idea of nominations and people being unavailable. I think as political parties and as people concerned here, we may or may not have our nominations available or not available. I think when we want to say we don't want these processes to be delayed, let us also not be the ones who delay our own processes. I think that we should be clear in this meeting that perhaps political parties now going forward, shall the meeting agree that we proceed with extending and also extending further nominations. Can political parties perhaps submit more than one individual, so that when the due diligence is done and all of the 5 names that I will have submitted, for example, say they're unavailable, can we not re-rotate once again? Because we know that we want each and every one of our own selections to finally become the evidence leader. But as a matter of principle, let us agree that when we go forward now, after this moment, we don't come back to this moment once again, because we know that if people are really, really good, because that's who we want people who are really, really good to lead evidence in this regard, they may not find themselves being available. And so for me, it is that, and I just wanted to assert that, and also to remind the meeting that there was never a limit on how many names could be submitted. I just wanted to make that assertion and that point. Thank you, Chair.
Thanks very much, Honorable Malema.
No, thanks very much, Chair, and good morning. I just want to touch on 2 points which were made here. One is that you asked the staff members to make a nomination, to look for a nomination and make a nomination or something like that. That is not the decision of the meeting. You come from a political party. And if you want to make a nomination, go to a political party and make a nomination. And let's deal with that, because you are not going to have more advantageous things than all of us, where the staff members do things that we were told to do as political parties. I think because when you are there, you are for all of us. And therefore, whatever resource you use there, you're using it on behalf of all of us. This thing that the chairperson is going to look for, what noise, we didn't say chairperson, because when we say chairperson, it means it's us. So it was wrong what you did. It must not be repeated. If a resolution says political parties, let it be political parties. If a resolution says the chairperson of the committee, together with political parties, shall look for evidence leader, then let it be done like that. I think we must not have a confusion when it comes to that. The second thing, there was another illiterate input which was made here, that when a person is nominated by a political party, that person will be aligned with that political party throughout this engagement. That's so illiterate. I mean, if you know how legal practices work, you should be ashamed to even suggest that. Because let's take, for instance, Advocate Ngai Toby. He has been representing EFF, he has been representing ANC, he has been representing different kind of people. Today, when you appear before the Constitutional Court, are you going to say this person once represented EFF, ANC, therefore they will always be aligned? It's so uneducated, and therefore it doesn't mean anything and not worth even being said on a prestigious platform like this one, Chair. But otherwise, I agree with almost everything that comrades have suggested, especially that we submit the names Monday. And I will suggest that when names are being suggested, let them be pushed to other political parties. If I say I nominate so and so, obviously I'll send to you and your staff members, Chair. And then your staff members do not have to wait for Monday. They just have to send to all political parties. Please find, or you can drop it in the group, please find the EFF nomination for evidence leader. So that we don't see those things for the first time. When we come, we all had an opportunity to make a preliminary investigation on these individuals. Thanks.
Thank you very much, honorable members, and thanks for the inputs. So there were a number of proposals. One that seems to be finding a lot of favor is that there's an extension insofar as allowing political parties to submit further names, but there's a disagreement or varying takes in terms of what the deadline should be. with those that the original proposal was 48 hours, which means it's by end of business on Friday, which allows the legal team to check availability and also due diligence, and to have that report both in terms of availability and any matters of due diligence to serve to be submitted to members by Monday, so that by the time we meet on Wednesday, at least members have had sight in terms of who's available, who's not available, but at least 48 hours before the meeting. So that's the first proposal. The second one is that the nomination be closes on Monday, as I hear you correctly, Honorable Malema, that it closes on Monday as the second one. And there was one which was asking for 7 days. So having accepted that the majority of members are agreeing on the extension, which deadline would you then propose to be the one? Having gone through this together with legal, I will say that the 48-hour allows enough time for legal to reach out to the evidence leaders nominated and get back to the members by Monday. If we push it to Monday, we might get here on Wednesday and ask for further time so that there's internal lobbying of within political parties. And I would maybe suggest that we take the 48-hour until Friday, but I'm open for those ones that feel that it should be Monday to indicate as such, unless we happy with 48 hours until Friday 4 p.m. and give legal the weekend and Monday morning to check availability. At times, it's not as quickly as the making a call because the senior counsels that will have been nominated also need to check their diaries to ensure that they give the right information. It might not be possible over the weekend. That will be my my submission, but allow Honorable Malema, if I think it was yourself and Honorable Kwankwa that suggested Monday. Is it fine if we put it for Friday 4 p.m. as the closing date for further nominations? Honorable Kwankwa, will that be fine? And Honorable
No
Malema?
objections. I have no objections to that, Chair, as long as there's an extension to the deadline. Thank you.
Honorable Malema, you happy with Friday 4 p.m. and then allow legal to use the weekend to get the availability and due diligence? I will. Honorable Litchfield Chabalala.
Thank you, Chair. Seeing that they are going to use the weekend anyway, for us that wanted Monday, could we say by Friday 1800, not 4? I mean, what are they going to do between 4 and 6 anyway? You can just give it till 6 that evening.
All right. 6 p.m. on Friday, but let them come as quickly as possible between today and Friday, 6 o'clock, so that if there's a nomination that comes today, that check of availability and due diligence can begin. Honorable Ngowe?
We support Friday's deadline. Thank you, Chair.
All right. Thanks very much. So Friday deadline, 1800 hours is supported. Can it be noted as such? And then the second issue, as it relates to the perceived conflict of Advocate Ngalwana SC, it was raised by Honorable Mahlaule and it was supported. I would like to place that on the for us to vote on that because there has been deliberations. I won't call for further deliberations on that. So we can either keep him, he's available, and that that matter be decided upon on Wednesday next week, or we decide today that we take him as not available in line with the perceived conflict of interest. Honorable Swart, is that a vote or is further submission?
No, very briefly, Honorable Malema and Dr. Schlope mentioned that we need to be very careful when we deal with the issues relating to senior counsel and perceived conflicts of interest, bearing in mind Section 58 of the Legal Practice Council and other other issues that were raised. I think we should hold this matter over because, again, allegations can be made about perceived, and I would suggest that we keep the name of that senior counsel. We don't want to narrow it down, and we can again consider this issue in the light of the submissions, particularly by Dr. Schlope, who's had wide experience in the matter of senior counsel and objectivity of senior counsel when they appear in matters. Thank you, Chair.
Thanks very much. Honorable Litchfield Chabalala, a different thought from Honorable Swart, or you are swayed by him?
No, it's not different. He actually took the words out of my mouth, but then me and him do think alike from time to time. I think I agree with him, and I would actually say if we are putting him on the vote because of that, we might as well do that for Hofmeyer too. I mean, I'm sitting here as it was raised by Judge Slope saying, okay, he's a serial person, so he's already subjective. So I would fully agree with what Honorable Swart has said. If we are going to go on that line, then we will tear all of them apart. And I'm not sure that's what we want, because if I hire someone to represent me in court, that doesn't mean that those people are for me. If anything I do, those people favor me. So yeah, I think I'll leave it at that, Chair, and support Honorable Swart.
All right, thanks very much. Honorable Mahlaule, I say that for now, Advocate Ngalwana SC remains in the pool of considerations until we decide next week, Wednesday.
Yes, Chair, because it's not personal. It's moving through a path of caution. It's not personal, so we are fine with that.
All right. Thank you very much, honorable members. So as things stand, we extend the time for new nominations to Friday, 1800 hours. But I want to appeal to honorable members and political parties. If you have a name today, please submit it today so that the team at Legal can check availability and do any further due diligence. It's my commitment that by Monday, you will have the list of only available ones. We'll no longer go back to the ones that are not available. We'll give the list of those that are available so that you have enough time to lobby one another in preparation of our meeting on the 29th of July 2026, and that we keep the 4 names that are available. It's Advocate Hofmeyer, Advocate Sleka, Advocate Jemmy, and Advocate Ngalwana in the pool, and that we are adding to this pool. So these 4 are accepted as available, and we are adding to the pool. That the new pool will then, of those that are available, will be circulated to members on Monday in preparation for the meeting of Wednesday. Agreed to?
Agreed.
Agreed.
Yes.
Agreed.
Thank you very much, honorable members. We now move to the next item, which are the terms of reference. Just to say that we did, thanks very much, honorable members, and for the extensive inputs that have been given to the terms of reference that were both in terms of the general reflection, but also specific proposals and amendments to the terms of reference. So how we are going to deal with this today, honorable members, is that there's going to be presentation. As you will know, that there was that document, a 114-page document that was shared We're going to deal with it. The content advisor will take us through in terms of the comments that we have received, but it will not be to read word for word. We'll also allow after this meeting, after we've gone through the presentation by the content advisor, general reflections, but then also subject the terms of reference to the same 48 hours for political parties to then be able to lobby one another where there are vast differences. There are areas where there's not massive differences, it could just be the wording, but where there's vast differences, that the political parties use the 48-hour window to consult with one another and move towards, let's call it, closer to consensus, so that by next week, Wednesday, we've got at least a document a much thinner document that we can work with for next week. Is that in order, honorable members? We allow content advisor to take us through the metrics, and then we give some reflections, and then the political parties will then, where you find that there's an input that you had made that another political party had a different input, then you can be able to persuade one another, and then you then submit that proposal to be considered for the new draft. Honorable Swart.
Okay, thank you. I did notice going through the document that there's a lot of overlapping, and there is already a large degree, well, maybe not a large degree, but a degree of consensus. And I'm not sure if it would help the process once we've gone through the presentation to note where there is already an alignment between certain parties. I think that might help us as well, Chair. Thank you.
Thanks very much, Honorable Swart. That's the idea, that where there's emerging consensus, we need to move towards that. But where there's divergence, then we try to move towards the center. Honorable Hlophe, did you unmute? You wanted to say something? Oh, all right.
I'm so sorry, Chairperson. My technology, I'm challenged here. I didn't want to say anything. I will speak in due course. Thank you, sir. Thank you.
All right. Thanks very much. Is the advantage of old? I nearly said old age, but it's maturity. It's maturity. Honorable Dagmo.
No, Chair, thanks very much. I just think I hear your proposal around anticipating another 48 hours, but I would suggest that we do as you've suggested, Chair, where we hear the content advisor, we have broad reflections. We might feel that we need another day or two. We might feel Friday is fine. So I'm just appealing that we reserve that decision about how much time we might need until after we've had the reflections. Thanks.
Thanks very much, Honorable Dagmo. I will now invite Advocate Nell to just take us through the metrics, and just to say that you don't have to read word by word, Advocate Nell, just indicate those areas that members need to note. Thanks very much. Over to you, Advocate Nell.
Thank you, Chairperson and members. I am sharing the full screen. So on the left-hand side, members will see the terms of reference that was sent. And on the right-hand side is the matrix. I do apologize that we did not have the MK party submission on the terms of reference. I worked on the documents that were sent to me, and that was those 8 submissions listed there. Chair, I see there's hand raised.
Just hold, Honorable, just hold, Advocate. Honorable Litchfield Chabalala.
Chair, thank you. I think I was waiting for you to say something. The MKP input is not included in these terms of reference. How are you going to deal with it? Although there's proof when it was sent. So when we proceed with what's here, how is it going to be encapsulated? How will we deal with it? I'm just asking. And also,
So-
I'm not even asking why it wasn't included. I'm not even there, although it does beg an answer.
Yeah, we will circulate the input of MK that will be considered as part of further developments of the terms of reference, and we'd like to apologize in terms of them not featuring here. But then, if I could just check with Temkosi insofar as the input of MKP. Temkosi.
Thank you, Chairperson. Good morning once again, still morning. Good morning once again, and good morning to honorable members. Chairperson, I think I need to be, maybe I have not received an NK party input on the on the draft TORs. I have received an input on the evidence leaders, which I read as part of the record. And yeah, that is in relation to this one, Chair, that is the 8, as it is going to be presented by Advocate Nell that I have received. Thank you very much, Chair.
All right, can we just double check Temkos together with the MKP, see where the line could have broken, but we'll circulate as soon as that line is unblocked to honorable members, and it will form part of the next round of the inputs. And I'd like to apologize if the error is on our side. We'll correct it. Is that fine? Can we proceed with this letter as we investigate where the document could have been sent? Because it's possible that the document that you're referring to might be the one that was deposited this morning on the group. Just need to be sure where it got missed in the process, but we will include it in the terms of reference. We'll definitely not exclude it as we develop the terms of reference. Thanks very much. Advocate Nell, please proceed.
Thank you, Chair. Then, following the discussions last week, Chair...
Just hold. Honorable Litchfield Chabalala.
Thank you, Chair. The TORs are in the same document that he says received. If he had read it to the end, he would have seen them. But yeah, it's water under the bridge. I think, as you said, you will circulate them. We can proceed.
Thank you very much. Advocate Nell, proceed.
Thank you, Chair. Yes, members will see in the old document where it said detailed rules, that will be changed because of the agreement that the committee had on the 24th to change that reference to terms of reference. And that was very well captured in the full, the lengthy submission from the EFF where they made those corrections in their document. So that was a standard that was already agreed to on the 24th. And then, Chair, a number of the submissions requested the replacement in the document of the acronym para for paragraph with the full word paragraph to be used. It does make for better reading. And then, Chair, there were different views expressed, especially regarding the time allocations. I will get to those when we get to that paragraph 16 or chapter 16, as I indicated it in the matrix. That's different proposals on the timeframes for evidence leaders' presentations, as well as members' questions. Chair, that first section, as we indicated, it's just the general comments. There was additional proposals, which we will consider last once we've gotten through the content, but I just captured them first in the matrix so that we have them all there in the up front. Some additions proposed by the ANC and then also by the EFF. So, Chair, that first section, we're just going through that. The title I've already indicated, that's where the change goes to terms of reference. And that is also supported by the IFP submission and the consequential changes that need to happen. Chair, then getting to the definitions, the first proposal in the definitions or for the definitions is a request to add a definition for sufficient evidence and prima facie evidence. So that was the first proposal we had. In terms of the ATM's proposal, that the definition for relevant motion should be amended. There is no such definition captured in the terms of reference, so that would be a new proposed definition to be added there. Also, a definition for impeachment motion to be added in terms of that definition proposal. Then in terms of the EFF, the submission on the definitions is to add a definition for assistant evidence leader. Let me just move up here quickly. So they would just need that assistant evidence leader to be amended to add that full description. That's about the abbreviation of paragraph, and then just to link it to the terms of reference. In terms of the definition for assembly rules, there's that proposal by the EFF. The proposal for change to the chairperson and chief evidence leader, as well as the committee secretary. The definition for day, Chair, I think it's the capitalization of the word day, because in the terms of reference, it's a small letter. And then the changes there for the evidence leaders. So those are all also following the consequential amendments. Also, some changes proposed to General Section 89 rules definition. That is more linked to that footnote as well. Then some changes there to hearsay evidence. Again, that's capitalization as well. Proposed changes to impeachment committee, the panel report, definition of present, president's representative.
Chairperson.
Thanks, Advocate Nell. We can no longer hear you.
Thank you.
Yes, Chair. After the president's representatives definition, there's the Section 89 inquiry definition, where there's a change proposed, as well as the Section 89 terms of reference. I'm just trying to line the two documents up, and then a change to witness, or an addition for a definition of witness instead of just the definition that we have of witness statement. So the additions here, Chair and members, is for witness, forensic investigator, and the customs control expert. These two definitions also link with the additional clause that the EFF proposed on these two appointments, which currently the terms of reference doesn't specifically make provision for. Chair, and then just further definition amendments is from the IFP that policy holidays, where that was a spelling error that needs to be corrected to public holidays, and from the NCC, a definition on what would constitute sufficient evidence. So, Chair, I'm just going to pause here for consideration of the proposals regarding the definitions before going to number 2, the legal framework.
Advocate Nell, you can proceed, and then we'll take the reflections later on.
Will do. Thank you, Chair. Then for the second chapter or paragraph of the document, Chair, is the legal framework. On this one, Chair, there's a lot of references to legislation as well as the rules of the House. So we must just be cautious when we are proposing amendments here that these amendments do not seek to amend legislation that is currently in place or the House rules, because we cannot amend those House rules. But the first ones that we had is from the ACDP. These are additions to the full set of the legal framework. Current ones are only 2.1 to 2.6. So they propose a new 2.7, 2.8, and 2.9. So the first one is on interpretation, as well as the nature in terms of the inquisitorial nature of the committee, and then the interpretation applied in a manner that facilitates effective discharge of the NA's constitutional responsibilities. So those are proposed additions to the legal framework. In terms of the ANC submission, they supported it as it is. In terms of the ATM, members would have seen in some of the general comments, some of those aspects highlighted in general will possibly flow through over to this section as well, but it wasn't specifically linked to a clause or a paragraph in this section. But the first is to expand on what are the powers of the committee. That could be an aspect that one would add, as well as indicated earlier in the general comments, and the objective of the committee, which is not specifically outlined in the terms of reference. So the nature and purpose of the proceedings, that's a proposed addition that would fit best within the legal framework section. And then what would happen if there's an abuse of the proceedings. The constitutional threshold consideration would also be an addition to this portion. If members feel that the references to the Constitution in the terms of reference as is in 2.1 and 2.2 and 2.3 and 2.4, 1 to 4, if those do not sufficiently cover what is proposed in this proposal by the ATM, this is what we need to make sure that they align, that we're not adding additional powers, but that the powers are reflected or sufficiently captured. That this next one was serious misconduct, and that is what would be defined as serious misconduct for consideration, given the reference of it in the Constitution for possible grounds for impeachment. The submissions from the EFF were indicated as track changes. In terms of this one, members will see the blue line there between 56 and evidence based on the EFF submission. That's a spacing that has to be corrected. In terms of 2.2, again, it's a spacing that has to be corrected. And for 2.3, it was also, and 2.4, it was spacing corrections that were proposed there because it's a double space between the number and the first letter there. In terms of 2.5, we'll see this is taken as the definitions from the rules. This is where legal has also indicated that we need to just be cautious if we are proposing additions to these sections. For example, this highlighted section here for a Section 89 inquiry, because it will change the definition of this as set by the Rules Committee. And I think legal can better cover those aspects, but it's just to keep in mind that we must be cautious trying to amend the Rules Committee's definitions. And then, Chair, they also proposed an addition of the footnote number 4 to be added there to refer to that case law. Then, Chair, the proposal under the sections dealing with rules 1 to
Advocate
9.
Nell?
Yes,
Nell?
Chair.
If you could just pass through. So this 2.5 is the rules as adopted by the National Assembly. So this will be replaced by the actual rules that were adopted by, or amendments that were adopted by the National Assembly. As a committee, we cannot amend the rules that were accepted by the Assembly. So if you could just pass to the next section in this regard. So this section will just take the rule as was accepted by the National Assembly. Thanks.
Will do. Thank you, Chair. Chair, the IFP's addition there on the legal framework aspect, it's just that they don't believe we need to restate the terms of reference because it's already operational in law. So there's differing views. Some parties want more information, more citations, where other parties say, since it's already there, we can just refer to, for example, the Constitution or the rules. We don't need to list all of it in the document. In terms of the submissions by the Patriotic Alliance, it's, again, linking up to the rules, but this one is more in terms of what the committee needs to confine themselves with. So that could link up with the proposed additions of the objective of the committee. Then presentation of the case. This is the sequence of how evidence will be presented. So this could be an addition, or this can go to section 16 or paragraph 16, where we speak to the evidence matters. The inquisitorial approach is just to make sure what that definition rolls through, and what does it mean to follow an inquisitorial approach. So, Chair, that was section 2. Section 3 is on the composition of the committee and the appointments of members. In terms of the ANC, again, because this is provided for in the rules, they indicate that it's not necessary to have it in the terms of reference. The EFF indicated the amendments to 3.1, and then they subdivided it with reference to the rules. So in terms of the EFF submission, it's to add those references to the rules. that are applicable for the composition of the committee. So 3.1 will then expand according to the presentation with 3.1, 2, 3, 4, and 5. Then the term of office for the committee, they are providing a longer provision for that 3.2. So that is number 3. Looking at the meetings and quorum, the ANC again has indicated that it's provided for in the rules, not necessary to expand here. The ATM may have some of the general comments that were indicated above under general comments in terms of how the meetings will be ran and the flow of the meetings that can be considered either here or under number 16. In terms of the EFF's proposal is to change 4.2 to read as follows regarding Rule 60 sub 1, and then to amend 4.3 by adding 4.3.1, a subsection dealing specifically with the meetings. And then also they propose the additions of 4.4 regarding the quorum, and that links it back to the rules. Those are those proposals for number 4. Under number 5, again, it's linked back to the rules by the ANC submission. Submissions listed under general from the ATM may impact here in terms of the decision making. In terms of the EFF submission, they propose the change to 5.1. It's in terms of the wording used there, the way the impeachment committee takes it instead of the manner in which. And then they add 5.1 reference to Rule 129N and the Rule 1582D. And then they propose the amendment of 5.2 to say that the voting must be must occur openly. In terms of number 6, for the chairperson, the ACDP proposes a new clause to be added. So that would be the addition of 6.4 at the end to say that the chairperson's ruling shall be final unless overturned by a majority. In terms of the ANC's proposal, they again are suggesting that it's already captured in terms of the rules, so it's not needed to be added here. In terms of the election of the chairperson as well and the powers of the chairperson. In terms of the EFF submission, they propose amendments to 6.2. It's mostly again regarding paragraph and terms of reference being added there. Amendments to 632. So they have incorporated 63221 and 21 and 22 so that it makes it a little bit they give greater explanation in 632 and expands in there. For 6.3, they make proposals for 6.3.1 and 3. Sub 1 and 3, again, that is the terms of reference in terms, instead of saying inquiry rules, and 634 is a paragraph amendment. Then for the committee secretary, Again, from the ANC, it's overtaken by events. In terms of the EFF, it's just the replacement of rules with terms of reference. And then in 7251, it's that addition of, or that replacement, taking out so as to and just making it possible to facilitate. Then under the chief evidence leader, the ACDP proposed insertions in 8.1. Based on the discussions that the committee had on the 24th. And then also for 8.7, after office, to add on good cause shown. It's about the removal. Then for 895, it's the investigators. This is the proposal to add those additional capacities. The approach was slightly different by the parties. EFF proposed entire new additions in terms of clauses that would specifically cover it, and the ACDP just proposed the addition of it under the evidence leaders section. And then 896, to ensure that they conduct the inquiry independently, fairly, and objectively, and present all material matters. And an additional insertion to 897. That's on participation by persons in the committee, witnesses being questioned, evidence being submitted, and if evidence is regarded as having been concealed, what would happen? In terms of the ANC's proposals, they've indicated that some of it might be too prescriptive. As the evidence leaders may need to or seek to adopt their own approaches. They indicated a partial agreement on the assertion of paragraphs 8.6, 7, and 9. 8.9 to 8.11 is regarded as operational, and 8.12 is supported. They do indicate that since the inquiry is inquisitorial in nature, that the evidence leader not act as a prosecutor. So it's just that there needs to be full clarity on the role of the evidence leaders, and then that they work in consultation with the committee, and that they do not limit the right of the members to put questions. In terms of the ATM's proposal, again, there's some tenets that needs to be fulfilled by the evidence leaders in terms of their work, that they need to assist the committee, lead evidence as outlined there in those bullet points. And in terms of what the committee will determine, the appointment of the evidence leaders, we are currently doing that process, but they do indicate those aspects appointed by Parliament. The independence of the evidence leader also links back to the ACDP's proposal on how they hold themselves to make sure that the wording is strong enough in the terms of reference. Additional proposals for disqualifying criteria for the appointment of the evidence leaders, and then on their declarations of interest. and a duty of disclosure. Further aspects proposed for the consideration in the section that deals with the removal of the evidence leader and the constitutional role of the evidence leader. In terms of the EFF submission, there are quite a few numbering and content changes proposed, and those occur from 8.2. So 8.2 will be a new insertion, a new clause proposed there. And then the old 8.2 becomes 8.3, and they also propose an amendment there. They propose an expansion to the old 8.3 to be a new 8.4 to give a bit more information on the chief evidence leader's requirements, and then also for the assistant evidence leader, what is required for that appointment to be done. Just on 8.6, is a change to 8.5. 8.7 is also a change to the old 8.6. The 8.8 also speaks to the old 8.5. So it's quite a few additions made there, or proposals made there by the EFF to expand on this particular clause. 8.9 would be the old 8.6. I'm just going down because that's again in terms of reference change in 8.10. The functions can be expanded by the committee from time to time. And then upon their appointment, the old 8.9 is reflected under the EFF's 8.12. So there's an addition there of 8.12.2 as well. The 8.12.2, which is the old 8.9.2, they proposed the additions of number 3 and 4 as well. And then splitting 8.12.4 into 3 separate extensions. So the EFF's proposal expands the evidence leaders clause significantly. Then the old 8.9.5 is 8.12.5 for the EFF submission. 6 is same. It's just the terms of reference and paragraphs, different expansion there. 8.13. 8.13 speaks to the old 8.11. That's all giving a bit more details to the affidavits and the information as would be submitted by witnesses. And the numbering and labeling of exhibits and annexures, which was also there in the terms of reference. The old 8.12 is now 8.14. There's some slight changes. It's not major changes in that wording. It's just an expansion with those other proposals on the rules and the terms of reference changes and the paragraph changes. So that goes up until 8/14/42. The NCC's additions. This is more regarding the appointment of the forensic investigators. So if we agree to have a separate clause on it as proposed by the EFF, then these proposals will have to be worked into that clause in terms of the appointment for the forensic investigators. Section is the president's representative. So there is, again, where there's references to the rules, there's a proposal that it's not needed. It's already in the rules. Correspondence to be dealt with administratively. Participation by the legal practitioner representing the president. And then the request that there needs to be further research done regarding the best global practices regarding impeachments and some of the parameters that are proposed. In terms of the EFF's proposal, it's to amend 9.3. It's just that there's some references to the inquiry rules in 953 and 96. That's just consequential amendments due to the changes of inquiry's terms of inquiry to terms of reference. Then under 10, general call for witnesses and documents. One proposal to remove this because the evidence leaders and the committee identify the witnesses and the experts to be called. And the general call can be dealt with according to Section 59 of the Constitution. In terms of the EFS proposal, it's again just the references to paragraph and rules to be changed. So for number 10, it's not too many changes proposed there. 11 applications to the impeachment committee. There's a recommended insertion from the ANC that the committee should be in a position to request declassification of reports. And when witnesses are providing evidence that are linked to classified information, what should be done in that instance. In terms of the EFF's changes there, again, it's terms of reference and paragraph amendments, and they propose the addition of a new 11.3. So it will change this 11.3, that it will be done after consultation and approval by the majority of the committee. In terms of meetings of the impeachment committee, The Action SA has proposed that 12.2 be removed. And in terms of the ANC's proposal, consultation with the committee and not accord the chairperson unilateral decision-making rights. And then amendment of 12.2, removing on their own accord, to make sure that that's done with the consent of the committee and consultation with the evidence leaders. They also propose the removal of paragraph 12.3, as the NA rules cover that provision, and they would support 12.4, 5, 6 to 9. Then in terms of the EFF submission, there's a third subsection to 12.1. In 12.1.1 of the consultation with the president's representative, so that the focus is just on determination by the chairperson and the committee as well as the evidence leaders. Then for 12.1.2, again, that would be held in the public, and the specific allocation of the venue is proposed to be the Good Hope Chamber. And then the addition of number 3 is regarding possible virtual hearings of evidence. Then for 12.2, they also propose an addition, or at least a change. For 12.2 and 12.3, there's changes proposed. This is to deal with additional members that may attend, and how, well, if they can participate, if they are there as an alternate. If there is exclusion of the media or the public, what would be considered under a new 12.3. Then in terms of 12.4, they just refer to the rules that would apply to the committee. And 12.5 also refer back to 12.3 and the assembly rules. Then in terms of the input further from the NCC, limited sessions being in camera, continue with openness and transparency. In terms of media coverage, number 13, ANC supports 13.1, proposes removal of the remaining provisions, and Rule 167 covers the hearings of the committees. In terms of the EFF's provisions, there's a few changes. So it's to quote Section 21 of the Powers and Privileges Act, as well as 27.2, not just refer to them. And then 13.2, obviously consequential amendments to the numberings. And then removal of, if available for that purpose, just that it must be broadcasted. YouTube channel, again, available for the purpose, has been removed in their proposal. And then for the social media aspect, 13.2.3, they add the additional highlighted portion there. And the NCC's one is also that limited in-camera proceedings. Conduct during or in relation to the proceedings. ANC's view is that the rules cover this sufficiently. Again, members would see some of the ATM's issues could fall under several sections and were captured under the general aspect. So the EFF submission. It's the addition of the president's representative and any other person. And they proposed the changes to 14.41 and 14.42. So it's on the address of the members. Opening remarks. There's a proposed amendment from the ACDP to 15.2. In terms of the ANC's submission, there's questioning sequence times. But that was an aspect that was indicated on the 24th that the committee needs to decide on in terms of the time allocations. Then 15.5, I think members, in terms of the submission, this might have been referring to 16 instead of 15, because that's where the questioning aspects are raised. The overall proposal is that the members be provided equal time in terms of their questions. In terms of the EFF's proposal, the proposal is to remove 512 and then to amend 5.1 as indicated, and to expand on 5.12. This is where the proposal comes in, where it changes from 1 hour to 30 minutes. And then there are just some aspects here. This numbering will have to be a consequential numbering that has to change. And again, the 1 hour that was allocated there be changed to 30 minutes. For witnesses, chapter 16, paragraph 16, there's quite extensive amendments proposed from the ACDP in paragraphs 6.1, 10, and 11. Especially linked to that provision on the president's testimony. There were quite a few submissions on the view. The committee had the view that the president has to. There's no if. So those indications will have to flow through in this section. And that's also the indication from the members. The president must present himself. And because of that decision, the terms of reference will have to change wherever that type of reference is. Time allocation proposed, again, 30 minutes for questioning. And specifically for paragraphs 16.7.2, 8.3, 8.4, and 9.2, the proposal is 30 minutes for the first 3 members of each party, thereafter 15 minutes for each succeeding member. So that's a differentiation on that aspect. Action essay, again, amends this 4th bullet point regarding the president's testimony. And consequential to that, then 610 would have to be removed. Changing may to must, leaving that time period there to 5 hours. Let's just get to 611. Leaving the 5 hours there, about changing in 11.2 the 5 hours to 6 hours. So this is an extension of the time there. And then 11.3, changing the may to will. So that's that portion over there. The ANC submission. Is to remove or a decision by the president not to testify based on the discussions, and then the adverse inference indication there by the ANC that needs to be removed. In terms of 16.3, to add Section 3 of the Law of Evidence Amendment Act, in the interest of justice test. And then a request there for legal advice on the decision by the president not to testify. And they support 16.7. In terms of the ATM's proposal, there's amendments proposed to 16.10 and 11. Again, that's on the president's appearance before the committee. And they propose those following amendments to 6.10 up to 6.16. In terms of summoning witnesses, again, that the committee holds the power. They expand on the duties of witnesses and legal representation for affected persons, and how those legal representatives should conduct themselves. They expand on the rights of the president and propose that amendment there. On the protection of witnesses, they propose the addition to exclude intimidation and threats. And false evidence or contempt, again, that would be linked to a witness testimony. And they propose that addition there as well. Okay, on the EFF submission, there's a few additions again that changes numbering and bullet points. So they propose amendments to 6.1, 1.1 and 1.2. This second, in terms of their proposal, will then obviously have to be third, fourth, and fifth. Insertion of 16.5 regarding witnesses refusing to provide documents or material required. And then amendments to 16.6, which would then become a new number according to the FF's document, 16.7. There to the old 16.7. So here, especially in 16.7.1, 2 hours is proposed to change to 1 hour. Number 4 for cross-examination and re-examination. Then amendments to 16.8. So the time in 8.2 changes from 2 to 1 hour. The rest of the timing stays the same. Then changes to 16.9.3. Further changes to 6.10. If the president elects to testify, that was not changed in the submission. There is a change there from 5 hours to 2 hours in terms of that questioning. But this change not being reflected here would be affected by the changes proposed earlier, that it would have to be consequential amendments that he has to appear before the committee. Changes to 16.11. Here's a time change from 5 hours to 2.2. Changes to 16.14. Again, that's terms of reference paragraph amendments. Changes to 16.15. So that's section subsequent changes, cross-referencing of sections that were corrected. There's a new insertion proposed on the examination of witnesses based on section 15 of the Powers and Privileges Act. This was proposed to come after 16.17. Members will see 16.17 just outlines that there has to be cognizance of sections 15, 16, and 17 when persons appear before the committee. And the proposal is to outline and add those sections, the wording of those sections in the terms of reference. The old 1619. Again, in terms of reference changes there, paragraph changes. There's also changes to the wording here. Does not refer to concurrence with the speaker. The issuing of warrants for persons to be brought before the committee. And just refers back up to the powers and privileges. Changes to 1620. There's again paragraphs in terms of reference changes. Then changes to 1622, legal privilege. In terms of reference, changes in addition to wording upon receiving written advice, not just the written advice. And then an addition of 1622(4) and 5 would then add to 1622. So these are new ones proposed. Additional requirements for the committee secretary to communicate granting of applications. What happens if there's an application refused? In terms of protection of vulnerable witnesses, there's a proposal from the IFP that needs to be strengthened in the terms of reference. In terms of the president's participation, input made there. And constitutional accountability. And then also that there needs to be consistency with the terms of reference. In terms of the NCC submission, the declassification concerns of reports. On the addition of objections that may be raised to questions or documents, and that the chairperson then rule on continuation of those questions. And who gets to ask questions and how. So that's in terms of the sequence of the questioning. And they propose a sequence of questioning to be added. In terms of number 17, evidence that will be presented. There's a proposed amendment to 17.6 on the adverse inferences. And that's linked back to the president's giving evidence or not. And that 17.6 should be deleted. If the view is kept that the president cannot be compelled to testify, then the following can be inserted. With the footnotes added there. Action SA proposes the removal of 17.6. In terms of the ANC, they supported 17, and then just the question on 17.3, whether we have the capacity to produce transcriptions in a timely manner. ATM proposed additions on the rules of evidence. And what would be considered as documentary and electronic evidence, and how that evidence is assessed. So this could fall under this section, but it can also fall under the committee's report. In terms of the amendments proposed by the EFF, there's amendments to 17.3. So it's to add admissibility that would have been admissible in a court of law. Amendments to 17.5. So that combines 5.1 and 5.2. They also propose the deletion of 17.6 and amendments to 17.7 regarding a number change and the removing of the word must here because it's already captured over there. So that's a editorial correction. In terms of the proposals from the NCC, it's again what constitutes sufficient evidence. In terms of the PA submission, versions that may be put to the president, and when those came in, prevent unsupported rumors being put out, how hearsay evidence and media material will be treated, and how documents will be controlled. (18) The ANC indicated support of the clause. In terms of the EFF, there's some amendments proposed there. So there's some editorial changes, so you'll see some commas being added and semicolons. 8.3 is changed. Those timelines are taken out. So it's made available within 4 days, the transcriptions. Written and oral submissions supported by the ANC. And that 19.4 is very valuable and must be kept. In terms of the EFF submission, there's some paragraph changes, which would be consequential changes that need to come in. Then also the addition here for rule 129M2 to be added. There's an insertion of a comma and semicolons, so it's editorial. corrections, amendments to 19.6 and 7. So that is about taking into account period used to answer the questions. So that's again on the time allocations. And the amendments in 19.7 are mainly grammatical corrections that were made there and editorial changes. For 20, the committee deliberations and decisions. Again, a lot of the submissions where there's on how evidence is dealt and assessed, and what has to go into the weight of the evidence applied, that can also fall under the deliberations and the decisions. The ACDP proposes changes to item 20.1 because there needs to be standards clarified. And they recommend that 20.1 be changed to read as indicated. Bold, and then also insertion of a new 20.3 in terms of the acceptance of evidence. ANC supported the section. ATM submissions, this is the standard of decision making, just to expand on that. The EFF's amendments is an amendment to 20.1.1. So they've shortened it. In 20.5, there's an insertion of a the. They propose the removal of 20.6. And an amendment to 20.7. Proposal by the IFP is on the burden of proof required. Seriousness of the consequences of the decision. Then on the committee report, number 21, the ACDP indicating amendments to either 21.2 or 21.1, wherever it will be best suited. So that would be the guide for the report based on these clauses. Also indicating all findings on material issues, an amendment to 21.3 or a new 21.3 regarding the material issues considered. In terms of the ANC submission, that there should be a change after subordination to affirm subordination of the terms of reference to the rules. And then reasons for findings need to be added there based on the ATM proposal, just to expand on how we do those reasons. The committee's report to the National Assembly. with the minimum contents that would be required in the report, recommendations that may arise from the inquiry, referral of possible criminal conduct, the implementation of the committee's recommendations, and the minority reports. In terms of the EFF submission, there were some amendments to 21.24 and 5. That's changing this whether or not to whether. And then the PA submission is to propose that that section be added. Then in terms of number 22, general aspects. So again, it's the paragraph reference that changes, terms of reference that changes. There's an addition or a removal of the and here. So members will see some of these have been highlighted. That's how we pulled it from the EFF submission. There wasn't any detail on why the sections were highlighted, but we've added it in here. And then there's changes again to paragraph and terms of reference. Changes into 22.8 there. There's a removal of the should here. Should the chairperson deem necessary, and change it to consultation with the impeachment committee. They've also removed the consultation with the president's representative in terms of that paragraph. Then for 23, commencement, publication, and citation. It's mainly these proposals by the EFF. Say that it's the committee that determines, not the assembly that determines. And then the way the rules are in there to change it to terms of reference. So Chair, that is the full matrix and the submissions that were received, not reading it word for word, but general outlines for the members to consider. Chair, it was a bit difficult to capture all the proposals because some were done as track changes on a document that showed old track changes. Some were general comments expressed by the parties without specific reference to the paragraphs that they would like to see changed. But those are all the proposed amendments that we have received. Once we get that one, once Timbenkosi sends me the one from the MK, I will include it in the matrix as well. And if members are going to send additional comments, we can do a final matrix document then as well, Chair. Thank you, Chair.
Thanks very much, Advocate Nell. Honorable members, that's the presentation, and thanks very much for doing justice to the comments that we received. Obviously, we didn't have a standard or a template that we asked members to submit their comments in, but you have done a great job in collating and classifying the inputs that came from the political parties, and I want to thank the political parties for submission. We will include, as I said earlier, the MKP submissions and ensure that they form part of the matrix. Honorable members, that's the document thoughts and also a proposal in terms of how we move forward with this. I had made an earlier proposal that we give a general reflection and that we then move to the next level where in the political parties where there's a violent disagreement with one another, they try to find each other, and that we'll have a much cleaner vision by next week that we can consider. I put the document to yourself, members.
Honorable Chairperson, I'm raising my hand. I don't think you can see it.
Honorable Slope, I can't see your hand and I can't see you, but I can hear you. I'll take it that you want to make a submission. I will recognize you, then Honorable Swart and Honorable Dagmo.
Thank you very much, Chairperson. Thank you so much, Advocate Nell, for a good presentation. It shows you started your legal career in the High Court. That's where you got your training from. But on a serious note, I just want to reiterate what we said earlier on. We did submit a document relating to both the evidence leader as well as our comments regarding these guidelines. That document, I resubmitted it in the morning. One of the things that we touched upon, no doubt, relates to what we firmly believe, i.e., the president cannot give evidence through a legal representative or an intermediary. Giving evidence through an intermediary is normally done in criminal cases where a minor is involved. Say a minor was raped, a 7-year-old child or a 12-year-old or whatever, and is scared of facing the perpetrator. We're not dealing with such cases here. We're dealing with an adult, and the information is peculiarly within the knowledge of the president. So he doesn't have a choice with respect, and I'm glad there seems to be consensus that evidence must be given by the president himself and not through an intermediary or a representative. Secondly, obviously, if the president chooses not to give evidence, the law will apply its course. The law cannot be redefined by us in this committee. The law is clear. If there is a case to answer and you choose not to answer or to lead any evidence to rebut that case which you have to answer will stand because there is nothing to gainsay it. That's what we mean. In another way of putting it, that's what we mean. Adverse inference will be drawn. That case will stand because there is nothing to gainsay it. So we cannot rewrite the law with respect for purposes of this impeachment committee. In short, where there is a case to answer and the president chooses not to give evidence, that evidence will stand against him and an adverse inference can be drawn against him in the same way as it would happen in any other matters. We cannot rewrite the law for purposes of this impeachment inquiry. The other important point that I wish to make, it is for the president must give evidence first. I want us to avoid a situation whereby there is going to be ongoing debate about when the president should give evidence. The president must give the evidence first so that we know that is going to define the scope of this inquiry. That is going to tell us what it is that we're dealing with, what has been admitted or what remains in dispute. It doesn't help for us to call several witnesses to come and testify or to give evidence in respect of which that is not in dispute at all. So the moment the president has given evidence, we'll all have to reflect and say what it is that still has to be covered here. Is there a case for the president to answer? And then the sequence of witnesses will flow from there. For example, we might want somebody to come and corroborate the version of the president because it's clear that that is the evidence of the president. If there is no need for any corroboration or evidence to dispute or gainsay that which has been said by the president, and we're all happy that he has given a satisfactory account, that's the end of the inquiry. So my view is simple. We will have, this is the view of the MK party. We are firm in our submission that the president cannot give evidence through an intermediary or a representative. Secondly, he must give evidence first because that's going to define the scope of the inquiry so that we know what it is that we're dealing with. If he chooses not to give evidence, and there are witnesses who have been called by the commission to give evidence, and he elects not to give evidence, surely the law will take its course. We cannot rewrite the law. Just a little bit about the standard of proof. We're obviously not dealing with a criminal case where proof is beyond any reasonable doubt. This is akin to civil proceedings where proof is on a preponderance of probabilities. I so submit. Thank you very much, Chairperson. Thank you.
Thank you very much, Honorable Hlophe. Honorable Swart.
Chairperson, thank you. I found the exercise very helpful with the metrics and to learn the other parties' proposals. And there is a large degree of convergence on a number of issues. There's a lot of detail, which I think we can probably agree. I want to support your proposal to allow an additional, I think you spoke about 48 hours for parties to make, to find each other possibly. I think Dr. Hlophe has raised the critical issue, and that is the wording as presently formulated that the president can elect to give evidence, and should he, firstly, the issue of through an intermediary, which we would not support according to our document. Secondly, the issue of whether he gives evidence at all, and should he not give evidence, whether an adverse inference can be drawn from that. And the present clause says no adverse inference can be drawn, and I think that is incorrect as a matter of law. A negative inference could possibly be drawn from a lack of giving evidence, or on the other hand, as Dr. Hlophe indicated, when one then balances all the evidence at the end of the day and the president chooses not to elect, then that becomes a factor, possible negative factor, when one balances on the balance of probabilities. Chairperson, I think this we need to appreciate, and that's why I made the introductory comments in my note, that this is a unique constitutional process. Whilst we draw from criminal law and civil law, and we are guided by that, this is a constitutional accountability mechanism where we apply an inquisitorial nature as to determine on an objective legal basis whether we are dealing with a delinquent president or not at the end of the day. I will give serious consideration to Dr. Hlophe's suggestion about the president giving evidence first, should he elect to do so, but we would seriously argue that there should be a compulsion for the president to give evidence, or at the very least, should he elect not to give evidence, that a negative inference can be drawn. But at this stage, Chair, I just want to indicate that we support your proposal for additional time. Thank you, Chairperson.
Thanks very much, Honorable Doug Moore.
Thanks, Chair. Chair, as you said, just a few broad reflections. I think it's important that, when we say that we embrace the ruling of the Constitutional Court, that we should also give particular attention to the paragraphs 139, 140, and 141, which is also why we as the ANC have motivated very strongly for a two-stage process. We know that certain reports have already been compiled, and it only makes sense that that's actually where we start. And I think we need to be broadly consistent as a committee, given that the work that we're doing is informed directly by the judgment of the Constitutional Court. And also, Chair, I think what was useful in regard to your response earlier in the meeting, we should be very clear that what we're talking about here is a narrow inquiry specifically into the resolution, the motion and the charges that were contained in that motion moved at that stage by Honourable Zungula. It's not about anything else. That is the motion that went to Parliament. It's the subject of a panel report investigation. And it's very important that we maintain the focus and the mandate of this particular impeachment committee. Thank you.
Thanks very much, Honorable Ngobeni.
Thank you, Chairperson. I think I just want to make maybe 2 or 3 points. The first is that I think we are all very much aligned with regards to the president appearing, and that, are we hoping that that will be absolutely unanimous? We don't believe that he should be able to give evidence in absentia. We also agree with the negative inference suggestion that has been made previously. We absolutely agree with that. And then we also want just to say that the entities that are suggested to be able to give or to be able to inform our process, we shouldn't be limited to those. Wherever we can find evidence, we should be able to do that as a committee. And so in the end, I think what we want to really just respond to is the idea, and I think it was Honorable Dagmore just now who spoke to the question of, being as narrow as limited to the motion that is before us. However, narrow should not mean that the scope of it is only limited, that it doesn't encapsulate what we want to find, because ultimately what we want is to be able to assist the committee to discover the truth around what absolutely happened at Phala, and that should be expressly what we hope to do in this particular committee. I also want to say the suggested entities, I think we spoke to this earlier on, should just inform our work and not necessarily limit to those particular entities that have been referred to in the terms of reference. And I think that we should absolutely broaden those. And then finally, I want to say that I think we'll agree with the additional time that, perhaps be in line with the 48-hour submission that we are making with regards to the evidence leader. Thanks, Chair.
Thanks very much, Honorable Mahlaule.
Thank you very much, Chairperson. I think the framework, the matrix, gives an opportunity now for parties to engage in a very sober way to find each other, because as and when you go through it, you can tell that there are many areas of convergence, and I think it paves the way to engage and find each other. Chair, I want to align with your earlier submission on how you want to deal with that and give parties some time to really interrogate the submissions and engage with each other. Where they find each other, they do. I just want to point something, Chair, that is of a concern to me. I find it not useful, and I'm not saying it's not allowed. but how it became maybe a problem moving forward on how the committee conducts its business. There is a certain paragraph, I can't remember which paragraph here, your legal people will look at it. NCC made a submission, and already in their submission, they say the submission of the ANC is in this manner and that manner. We don't agree with it. One wonders where did they get that submission for them to not put their submission forward, but look at somebody's submission and start talking about it. It may, if we were given some equal opportunity for us as well before we submit to know what they submitted, we probably would have an equal footing. It's just a concern, Chair. I'm not making any suggestion on your office, but it leaves us wondering what happened, and maybe moving forward, we may want to deal with that. We don't have a problem with any party saying the ANC, we don't agree with it and all of that, but it bears some question to actually comprehend how another party got to know what would be the submission of the ANC and not submit what is meaningful, but criticize another party. Thank you very much, Chair.
Thanks very much, Honorable Mahlaule. I will respond after, because that's a serious concern as well. Honorable Daniels.
Thank you, Chairperson. Chairperson, a right is not a duty. And we believe that the president cannot be compelled to testify. His participation is a right to be heard, not a duty to give evidence. And non-testimony should not have an adverse inference because it can't be weighed against the president when we consider the duty and the right aspect that I've mentioned. Chairperson, Rule 129M1 provides that the impeachment committee must proceed to establish the veracity and, where required, the seriousness of the charges and the report to the assembly thereon. Now, the question that I have, Chairperson, is if the committee must establish veracity and seriousness, may the president be required to answer before the evidence relied upon against him has been identified, presented, or closed? I don't believe it is the case, Chairperson. The president has a right to answer a case that has first been properly presented. He should not be required to disprove an unformulated, shifting, or hearsay-based case. So, Chairperson, you know, we must consider proposals that the evidence leader must first present the evidence upon which the committee is asked to rely in relation to each charge. The president must be provided with a final issue list, such as evidence bundle, witness statements and summaries, expert material, and any adverse material relied upon before he is called upon to answer, Chairperson. The president is not required to answer an allegation, version, or proposition that has not first been placed before the committee as evidence and identified as material relied upon against him. Because, Chairperson, we must consider that this entire sequence is not a technical indulgence. It's a practical content of procedural fairness, simply because a person answers evidence and not suspicion, Chairperson. And it's on that strength that I base what I've just said, Chairperson, for your consideration. And there's so much more to consider. Having perused each party's input, that I appreciate the fact that we are going to come back to have a bite at this in a more effective and diligent way. Thanks, Chair.
Thanks very much. Honorable Zungula.
Thank you, Chair. Let me start, Chair, by maybe dealing with the issue of where or why we're here. We're here because there's prima facie evidence of misconduct and violations to the Constitution by the President. And because there's prima facie evidence against him, it is not a suspicion when that is put against the President. It is not hearsay. It is not something that could be interpreted as if it is just mere suspicions that have been put against the President. So the question of the President coming to testify, it is one of the most paramount issues that need to be dealt with, because you can't have an inquiry over the President and the President does not come to testify, because him testifying, that is an integral part of the ideals and the purpose of the Section 89 process of holding him accountable. Therefore, you can't hold someone accountable without having that person coming to testify and answer to what is put before him. Something that is based, most importantly, on the independent panel report. The President will not be asked about anything else besides what is the reason why we are having this committee, which is the independent panel report. Which brings me to the other point, that the issue that we're dealing with here is not that there is a public protector report that found that there is some issues, and then that public protector report led to the formation of this committee. We're here in this committee because of an independent panel report. So the assertion that we must rely on, or we must start with the reports that may have been done by other institutions, I don't think that would be a wise move, because in some instances, the outcomes and the views of those particular institutions fundamentally differs from what the independent panel found. For instance, the public protector's version of paid work is different from the independent panel's version of paid work. So how can then you bring the public protector on her version of paid work to come and testify as a basis, whereas the issue here, we are dealing with an issue of the independent panel report. So no reliance when it comes to when we are starting must be placed on those particular institutions. Reliance must be placed on the independent panel report, as it is a basis of the impeachment committee. That's why even the court judgment is very clear that the independent panel report, according to paragraph 139, the impeachment committee must proceed up until until the report is set aside. That judgment says nothing about SARS, the Reserve Bank, or anything else. And then the other issue is that we are in a full-blown trial as we speak, Chair. It's not like we are going to start another process that will lead to another process. This is a full-blown trial. Therefore, we can't say we're going to be listening to these particular institutions to make a determination if we can have another step. The step that we're in now is a full-blown trial. And my view is that we must start with the independent panel report as a basis, because that is why you are here. The last issue is the issue of the witnesses, where we must allow witnesses, we must not close off witnesses to come and testify, regardless whether a witness used to work in the intelligence of the country. They must come testify, they must come bring evidence, because this process must be an evidence-based inquiry, in which we're trying here to ascertain the truth. Therefore, we can't then block out individuals who may assist the inquiry with evidence on the basis that they used to work in the intelligence of the country. The question that perhaps would need to be answered by the legal team is that when Chief Justice Ngobo was delivering the report to the then Speaker, he made a statement that their work is done. And now that report becomes a report of the Speaker. Now, in the case whereby, as a point of departure, as it has been proposed, that the independent panel must come and table the report, how would that look like if the authors of the report are of the view that their work was done the minute they handed over the report? And even in the litigation that is currently happening, the assertion is very clear that abangeni ndawo. So what then would be the way to deal with that in terms of ensuring that we get their view, their wisdom, and their understanding, which led to that report with those conclusions, and at the same time deal with the question of can they come testify or can they come to table their report? Thank you.
Thank you very much, Honorable Litchfield Chabalala.
Thank you, Chair. After this, I will excuse myself. Honorable Zungula has covered me on the legal technicalities that govern this, and I'm glad I'm speaking after him. So I will do what is done in the military, where a junior speaks to a senior and they say permission to speak freely. So can I speak freely? We are very busy, GNU. This is an election year. If you are calling us here to come and talk to the Sudanese businessman, to the immigration officer who let such a huge sum of money pass through our borders, or to a bank that allowed this man to withdraw such a large sum of money, you can't even withdraw dollars directly in this country. You want us to talk to the workers at Palapala Farm, every one of them talking about the president, but the president is not appearing. You are really wasting our time. I say again, it's an election year. If that's what we are formed for, in the words of Honorable Daniels, we are here to establish the truth so that we don't drag the president to the impeachment committee based on hearsay. But you want us to conduct that process precisely based on hearsay, because all of those people will be talking about him, but he's not appearing. So honestly, I beg, or so say Nigerians, GNU, don't push us to a corner where, as some of us in opposition have to come into boardrooms and say, do we really want to be part of this impeachment committee, or do we just leave it as a GNU process? You can't waste our time this way, not this year when it's an election year. So let us be very clear from the beginning. If you want to establish the truth, this whole case is about the president, trying to understand what is so scary about him appearing in the impeachment committee. Also, just permission to speak freely again. Do you think if those dollars were found in my house, I would still be breathing today? I would long have been in jail. So, man, let's not confirm what some of us in opposition are already saying, that we are dealing with a legal process that is very captured in this country. Don't confirm that stereotype. Can we be serious about ourselves? Thank you, Chair, and I would like to excuse myself. Thank you, colleagues, for this meeting.
Thank you very much, honorable members. That concludes the general reflections. I think the sense that I got from everyone, it's that we also extending this, now that we've had the presentation on the party submission, we're extending it with the same deadline for 8 hours until 1800 hours for political parties to confer with one another, and where there are disagreements, at least submit a consensus view in that regard, but also for ourselves in the background, we can be able to then clean up the document so that by the time we meet next week, it's not a 114-page document. We remove all the commentary around the proposals, and we are left with the proposal so that it becomes a lot easier for us to deliberate on that. Honorable Zungula?
Chair, just to register my request that can you also look into the role of the independent panel?
I will come there. I'm taking from the top, Honorable Zungula. I'm coming there. So that it's insofar as the terms of reference, can we then do that, honorable members, so that the documents that will then submit for the meeting, we are going to have a meeting next week, Wednesday, on the 29th of July. So we want to submit those documents by Monday. So if you find one another, please let us know and submit the consolidated view together with the party that you have agreed with. It will assist us. It will assist us greatly. There are two aspects that we have to check. So there's one that Honorable Zungula has tabled insofar as the independent panel report, whether we can get the authors of the independent panel report to come and table the report to the committee and interact with ourselves. I think we have to write to the authors, but also together with legal to check what's possible in this regard. It is also my desire that the authors of the panel report appear before the committee, table the report. If you remember very well, even though one was not a member of parliament at the time, the report was handed to the speaker. It was never briefed to any committee in parliament. So this is the committee that's supposed to be briefed on it, taken through it, all the considerations of the evidence and how the panel arrived at its decision. I think we can all benefit from that, and we'll ask legal to then deal with that issue. I was listening, honorable members, to the input first that was given by Honorable Shope, and then the subsequent inputs insofar as the president's appearing or testifying before the committee. And there's I think for me it leaves a bit of a legal question that I would like to ask legal, if at all, if they can assist, whether we can compel the president to testify, and if he doesn't, what does that what will that mean for the committee? Because I think there's that issue around the negative inference that might have to be made in that regard, because so that we are on the right side of the law. I know that we might have our desires as members. We also don't want the rules themselves to be challenged if someone chooses not to testify and believe that there's no case to answer. And also in terms of what Honorable Shope have proposed, that the president testifies or gives his version or appears before the committee first. If I can ask legal to just look at that matter, so that when we consider that particular clause in the terms of reference, we do have some legal backing, and if possible, legal can then prepare that briefing to the committee for next week Wednesday, insofar as the president is concerned, and also looking also in other, they will use the case law and other jurisdictions where impeachment processes will have taken place. Will that cover us members, so that by the time we discuss this particular matter, because it was also a matter that we discussed last time we met in June, that legal can go a little bit deeper to help us get to a decision on this particular topic. Can we agree to that, members?
Yes, agreed, Chairperson. Thank you. Agreed from my side. Thank you.
Thank you very much.
Very progressive, Chairperson. Thank you very much.
Thank you very much. Thank you very much, members. Insofar as this item is concerned, the decisions that we are taking is that firstly, we are giving political parties 48 hours, so until Friday, 1800 hours, to confer or lobby each other on clauses that they are differing with, and then to submit to us the agreed position so that we can clean up the metrics for the meeting on the 29th. That's the first one. The second one is that together with legal, we are going to write to the authors of the independent panel report to ask them to in terms of the availability to present the panel the report to the committee. So that's the second one. And then the third one, it's for legal to assist us insofar as the appearance of the president, or if the president might choose not to testify, what are the options that are available to the committee so that those two clauses in the terms of reference are properly clarified. So these are the three decisions insofar as this item is concerned. Honorable Dagmo, did I leave something out that you said?
Chair, I just wanted clarity that in your summary around communicating with the authors of the independent panel, and you've also referred that the team in your office would look at some legal aspects. I think could we just also agree to ask them to consider in regard to both, okay, the interdict, there will be an outcome on Friday, but in regard to the review application, whether it would be prudent to have that engagement before the review panel, the review process has come to a conclusion as to whether there are issues with that panel report and so on. I think we must just get an opinion on that. I'm just concerned that we invite without looking at the implications of possible judgments down the line.
I see two hands, Honorable Mauto and Honorable Zungula.
No, thank you, Chair. We didn't want to engage now because you said we were going to engage as political parties and then come sit next week. But now we are forced to speak because we see that you are already moving. One, it must be noted that the EFF objects to the president not giving evidence himself. Will be failing the people of South Africa. Will be failing ourselves, will be failing in our duties to hold the executive to account. He's an individual who's been elected into an office, not through lawyers, by him, and him taking the oath of office. So he must come here. The same way he answers questions in Parliament, that's holding the president to account. He is now compelled, not even by Parliament, by the Constitutional Court, to come and be held accountable here. There were no lawyers when he took an oath of office. There were no lawyers when we were electing him. So we vehemently disagree with any notion that the president should speak through lawyers. That's number one. Number two, Chair, the Constitutional Court is very clear. This matter, this report, independent panel report, must be referred to the impeachment committee. There's no legal opinion that you need to seek in relation to the review application tabled by the president. We're continuing until such time that the report is set aside by a competent court of law. As it stands now, there's no such a judgment. The judgment we have in front of us is the one that says the matter must be referred to the impeachment committee, and that's exactly what we're doing. So I oppose the proposal that says go and seek legal opinion. We don't have money. Our people are dying. Children are falling into pit toilets. Let's save the little resources of the state and focus on things that are going to help us take us somewhere. You don't need any legal opinion on a judgment that is tabled or was issued by the Constitutional Court, the highest court in the land. Thank you, Chair.
Honorable Zungula.
A quick one for me, Chair. I initially thought I'm done speaking for the meeting because you were done with your conclusions. However, maybe I'm rushing, but we can't allow a case where the process is are second guessed indirectly, because there is a court ruling that has led to where we are, and the work of the committee must proceed up until that independent panel report is set aside by a court of law. Therefore, it cannot be that even the authors now of that independent panel report are asked to give an opinion whether their report is actually going to stand legal scrutiny, because the suggestion that has been made is basically saying, as the authors of the independent panel report to advise when it's taken to court, will it survive constitutional scrutiny or legal scrutiny? And without being biased, there is no person who can then say, no, I think my report was shoddy, therefore let's hold off up until those processes are done. The process must continue. If we meet next week, we decide, we conclude on the evidence leaders, we conclude on the terms of reference. The following week, we must have the independent panel, Chief Justice Ngobo, and team coming to table the report, if possible. There need not be any form of delay up until those legal processes, because that is not what the Constitutional Court actually crafted in their judgment. Thank you.
Thank you, Honorable Mutambi.
Thank you, Chairperson. Yet, well, we agree that this matter must proceed. But, Chair, I think we stand to support your recommendation on that you seek a legal opinion also on the issue on the election, whether to testify or not, because that will provide a balance and clarity on the constitutional right to remain silent, because it's there. I will want to support that. And then secondly, Chairperson, there's an issue that Dr. Tope raised on the issue around the standard of proof on these matters, whether it's on the balance of probabilities or beyond reasonable doubt that relates to court, both civil and criminal approach. And then the question that arises, Chair, is that which standard of proof is used to determine serious violation of the Constitution? And the Constitution at the same time does not define it or its actual threshold. That's why it will be important for you, Chairperson, as we proceed, when we move towards, you also seek a legal opinion to that. But we support that matters that you said you must seek legal opinion. Thank you, Chair.
Thank you very much. Thank you very much, members. Just so that we are clear, and I'll start, Honorable Zungula, to say that what you had asked was that you want us to then ask legal, not that we are going to an external counsel and so forth. There are legal advisors to this committee. The first point of call for us, or for myself as the chairperson, is the legal advisors to the committee that then looks at this matter. So you had said, Honorable Zungula, that the panel had said that they say their work is done. Now we need to request them to appear before the committee. I said that together with legal. No, when I say legal, I'm referring to the legal advisors to the committee, which is Ms. Suen Isaac and Mr. Michael Prince in the first instance. So we are not going to spend any extra money because they are the employees of Parliament. In the first instance, they are going to advise on the question that you asked, whether we can call them, and then if we then say we can call them, then we write a letter asking them to come and appear before the committee, like we do with any person that we would like to appear before the committees of Parliament. That's what we're going to do. And it is the same insofar as the president. The first instance, we look at the legal advisors, they give the legal advice. If the legal advice from the legal advisors of the committee, it's of says that no, this particular matter requires an external person to give an opinion, that matter will be brought to the committee. But what you will have will be from within the legal unit in Parliament. I'm not one to just quickly rush to an external senior counsel and so forth to try to get legal advice. In the first instance, we use the legal advice in that regard. And it's important for us to also be informed of whatever recourse that it's available to us in a case where, let's say, either the president in this particular instance says that is not compelled to testify before the committee, so that the committee, when it finalizes its terms of reference, it can be adequately informed, and not only we go with just our own wishes. So I'm trying to say, as a committee, we need a bit of background information, or at least some view on this before we finalize the terms of reference. It was not to say in any way that we cannot state in our terms that the president must appear, but is to say, all right, what are the options available to us? And that work will be done by the legal advisors that are assigned to this committee in the first instance. Honorable Maute?
No, thank you, Chair. You know, Chair, we should not go around in circles all the time. We've been here before. There was a full impeachment, that process that was taken by Parliament for Advocate Busisiwe Mkhwebane. And that should be our base. That should be the starting point to say, what lessons did we learn from that? If you remember, Chair, I was sitting in that committee. You too were sitting in that committee. The initial point was that Advocate cannot be afforded the opportunity to have legal representative. And then the committee took a resolution that we are not affording her that right. She had to go to court to seek intervention for her to have that right. And then the court agreed with her that she has the right to have a legal representation. But the court did not agree with her on her giving testimony or evidence herself. So why are we now changing the rules? Because now it's the same process, it's the same impeachment process, just different faces. But we want now to pretend as if we were never here before. No, Chair, you should have already by now sat with your legal team and your staff to advise you on what has, or refresh your mind, because it's not to advise. You were here. It's not very long ago. Me and you were in that committee. So I don't understand why we are now saying we need a legal opinion on whether the president can come and testify or not. That question does not arise. The president must come and give a testimony. We agree that his legal representative can sit with him, but they cannot answer. They don't answer for him in Parliament. This is still Parliament. There's nothing different here. So let's not waste time over things and waste money. And the legal team should be seized with the work that is meant for the committee. There's a lot of work. There's a lot of paperwork that still needs to be put in place. Instead of going around in circles who are here for the first time. Why not? At least we've got that experience, Chair. Please, let's move in that order. Thank you.
Thank you very much, Honorable Maudwe. We will move in that order. Honorable Maiman, I saw your hand and then you lowered it. Are you covered now?
Yes, Chairperson. Suffice to say that what I'd wanted to understand is that I think if the committee was to table a report that Parliament needed to vote on to meet the constitutional threshold without testimony from the President, I'm not sure how that would serve Parliament in its interests. That was just maybe a question I wanted to put forward, but I think the other speakers have covered us in terms of where the matter goes. So I will yield it at that point.
All right. Thanks very much. I take all the points that have been made, and we will take lessons from.
Maybe Muruti Maimane should have prayed for the chair.
Aye, Maute. No. Thanks very much. We will proceed. It's important that at all times, also when there are some legal questions and these matters come up, we also satisfy ourselves that we are on the right side of the law, because this particular matter, as I always say, is the first of its kind, and we must at all times be on the right side of the law, because there are various ways that these matters will then be dealt with. But we'll proceed on those three resolutions in this regard. Can we then go to the last item, which is the minutes? Temikosi, can you please take us that item, the minutes of the previous meeting?
Thank you very much.
The minutes were circulated, because just go to the resolutions of the meeting.
Thank you very much, Chair. As I present the minutes, you are correct. They were presented to the committee. Sorry, they were circulated to members. It is the minutes of the 24th of June, our last committee meeting. And as you have indicated, Chair, I'll just go down at the bottom where the committee made the resolutions, wherein after the deliberation, it was resolved that all political parties would be afforded until Friday, 10 July, to submit the nomination of candidates for consideration as evidence leaders. The same resolution was made in relation to the TORs, and was also indicated that the committee secretariat should provide members with a list of all parliamentary support staff supporting the committee together with their respective roles. Committee agreed that the senior evidence leader would not be subjected to a vetting process, as that would be time consuming and could result in delays. The appointment of junior or assistant leaders will be left to the senior evidence leader. The committee further agreed in principle that additional specialist support may be required, and this could include investigators with expertise in forensic investigation, exchange control matters, and data analysis. And the last one, Chair, was the draft directive which was presented outlining the appointment of the evidence leader was adopted with an amendment on the appointment of junior evidence leaders. And then we adopted the minutes of the previous committee meeting, Chair. And also, Chair, as you will be moving for the adoption, I think there's two important issues that you might want to address. One relating to the concern that was raised by Mr. Mahlaule, and the other one relating to the document that would have been submitted by MKP. Thank you very much, Chair.
Thank you very much. I will deal with that issue after we have gone through the minutes. Are there any corrections to the minutes, honorable members? I don't see any hands. Any mover for the minutes as a true reflection of our last meeting, Honorable Dagmar?
Thank you, Chair. Yes, I would like to move for the adoption of the minutes as presented. Thank you.
Thank you very much, Honorable Dagmar. Any seconder?
May I second, Mr. Chairperson?
Honorable Hlophe, Honorable Daniel second. Thank you very much, honorable members. There were just two issues that as we move towards closure, that I just need to raise. And so there was one, the issue around the input of the MKP, that we had missed them. I think we missed them because they were submitted to the WhatsApp group and without context. If I could just ask that any communication, especially whether it relates official communication, be directed to the committee secretary, and I can be copied on those conversations, but let's not submit the documents, especially of this nature, through the WhatsApp group, because without context, because they do sometimes get lost in there. Let's use the official channel, which is the email to the committee secretary, but we have taken note of that document, Honorable Hlophe, that MK has submitted. Can we